I hope you had a really good holiday season, and now we're back at it. This is unlocking the hidden legacy of digital assets. The RUFADAA, or the Revised Uniform Fiduciary Access to Digital Assets Act. These names are just a complete mouthful. But these tech companies like Apple, Google, they're all legally forbidden from sharing the data with even your spouse or other family members. So you have to give them explicit consent prior to your death. A general power of attorney, if you become incapacitated, is still not enough. If you don't ahead of time give them the access, you could run into issues. So what do these tech companies don't share with you by default? Well, they're not going to share anything, your iCloud data, your Facebook information, unless you set it up. So you add yourself as a legacy contact, or you add your family member as a legacy contact, or for Facebook, some legacy contact designation. And they both have these processes, and that's going to provide your beneficiaries or your family that information if you fill that out ahead of time. So step number 1, the big tech legacy settings. For your Google, you're going to have a situation where they have an inactive account manager. So you go to your Google account, set up the inactive account manager. You can designate a trustee or a trusted person to receive your data if you haven't logged in for 3 months. So you pass away, boom, nothing's going to happen. And then after 3 months, Google's going to reach out to your trusted contact. This ensures your family can access your emails, photos, documents without needing a court order or your passwords. This is a nice system that Google provides. It's a simple, it's a built-in tool that works right with Google's ecosystem. This is a first step to give your heirs real access to your digital life if you use Google. Apple. This is a legacy contact is the term, an iCloud key. You might refer to it as the iCloud keychain. So in Apple's setting, you go to passwords and security, legacy contact, generate a special recovery key that your family can give to your Apple to unlock your iCloud messages, photos, and contacts. This key bypasses the need for your passcode and allows your loved ones to access your digital life immediately after your passing. This is a powerful privacy respecting tool that respects your digital footprint while ensuring access for your family if you use Apple. Step number 2, password manager as a fiduciary tool. Your password manager can give emergency access. So stop writing your passwords on paper. They expire, they get lost. Use a password manager like Bitwarden, 1Password with an emergency access feature. You can nominate a successor who can request access if you do that. If you don't deny it within 7 days, for example, the vault automatically will open. This involves the zero knowledge problem. Even the company can't help your family, but your designated person can. It's a secure, legal, and modern way to ensure your digital life passes smoothly. So you could use this in a way to not provide all your information. Maybe you don't want your family to have all your passwords. If you're privacy conscious like that, you have some passwords that you don't, some passwords that you do want to give, use 2 password managers. Step 3, your high stakes assets. This is what a will can't handle. Right? For example, a will is not going to be able to help you with your cryptocurrency per se, other than leave it to my beneficiaries. But if you're using cold storage, that might not be enough. It certainly won't be enough. For example, you have a blog, you have royalties, you have some kind of a book, maybe you're an author. That income from that, you could put into an LLC and turn it into its own estate planning process. Cold storage with crypto, like I mentioned a minute ago. If you hold crypto with your own private keys, you must store your seed phrase in a fireproof safe or a bank vault, some kind of a safety deposit box. No seed, no recovery period, and that's at a minimum, right? I mean, you could just have your key somewhere safe in your house, wherever you put your important information. But if you're worried, maybe you got a lot of cryptocurrency and that's just not an option, just know if you lose those keys, you're toast, and your family is not going to be able to reach out to the cold storage provider, whatever software you use, because it's typically a zero knowledge situation. Same thing as your passwords. They're not going to be able to reach out to your password manager typically to resolve that because it's a zero knowledge. Income generating content. Maybe it's a YouTube channel that's going to continue to produce assets. Maybe it's a blog that's going to continue to produce income. Maybe you have an Etsy shop that's going to continue to produce income. So you're going to give your family the ability to continue to run those businesses via your will or your living trust. And you should have those potentially in an LLC so that you could avoid probate and just keep that running. There's not any delay there if you have it in an LLC and you set that up correctly. So because a business interest is a tangible asset that transfers more cleanly through a trust. Maybe you consider doing a trust instead of merely doing a will, which most people can just get away with just doing a will. But if you have an LLC and then that LLC is held by the trust, it could be a very clean way. Most people don't have this kind of income producing assets. They pass away and then everything stops. They don't make any more income with anything. And so they don't need a trust for that reason. But if you do, this is really could be something to look into. So it turns a digital account into a legal entity. This means your heirs inherit a real business, not just a login. It's a smart, legal, and future-proof way to protect your digital income. And step 4, the last step, the language in your documents is important. So update your legal documents. Your will must include specific language about digital assets. Simply saying, I leave my phone to my wife is not enough. You need to specify which accounts, which access rights, and which legacy contacts outside of your will. You don't put that information in your will, but you're going to put that information in some kind of a memorandum or some kind of a list format so that people can actually access the things that you want them to. Those are kind of all chunked together in one thing, but those should all be separate. So yeah, the RUFADAA should probably be included in the legal documents, but the pass-through manager and your LLC structure and all that, you may have that separate. You're going to look at each one of those individually. So this ensures your family isn't left in the dark, legally or emotionally. Without this language in somewhere, either like I said in your estate planning documents or in memorandums or separate, your will is incomplete and your digital life remains a ghost and may never be recovered. If you enjoy content like this, make sure to subscribe. We're here to help.